Thank you. Good afternoon. I'm Joyce Hagan McIntosh. I've worked as a librarian in a public library for the past 15 years, and I'm currently working with the Freedom to Read Foundation to provide educational programs related to intellectual freedom. Our program today puts the spotlight on minors and their freedom to choose, read, and view the materials that they're interested in. Some of you may have experienced challenges in your workplace. Some of you may be wondering why this is even a topic. Here are some current statistics. Last year, the ALA Office for Intellectual Freedom received notification of 275 challenges. Staff estimate that 85%, I'm going to repeat that number, 85% of challenges remain unreported. On the top 10 challenge list from 2015, 8 of the 10 books were challenged for reasons related to minors and were considered unsuitable for age group. Challenges that you may face on any given day could range from a patron asking to see a list of every person who has checked out a Harry Potter book. That happened in the library I worked at, to an intense, drawn-out court case over what content could and should be included in school textbooks, or what titles are appropriate for your student summer reading list. Our speakers today have each worked in different ways to provide access for minors, and staff from our organizations, the Freedom to Read Foundation and the ALA Office for Intellectual Freedom, have been working for over 40 years to support librarians, parents, readers, and authors who are working through these complex questions and situations. Our first presenter today is Theresa Chmara. She is an attorney in Washington, D.C. and the General Counsel of the Freedom to Read Foundation. She's the author of Privacy and Confidentiality Issues, a guide for libraries and their lawyers. And Theresa's been a First Amendment lawyer for over 25 years. She's a frequent speaker on intellectual freedom issues in libraries and a contributing author for the Intellectual Freedom Manual. She's also a frequent author for the American Association of School Librarians Knowledge Quest Journal, and one article that she's published for them is, Do Minors Have First Amendment Rights in Schools? Theresa not only knows the law and has the knowledge needed to share it with us, she happens to be my favorite person to listen to at briefings or committee meetings because she explains cases and how the law applies in such a straightforward, understandable manner. And then our second presenter today is Crutcher. Chris is a well-known YA author. He spent years as a teacher and then director of a K-12 alternative school in Oakland, California. And after that, he worked as a therapist specializing in child abuse and neglect cases. Those experiences and working with teens inform his 13 novels and 2 collections of short stories. Chris has received a number of awards, and he says his favorite 2 are Intellectual Freedom Awards, one from the National Council for Teachers of English, and the other from the National Coalition Against Censorship. 5 of Crutcher's books appear on an American Library Association list of the 100 best books for teens of the 20th century. And yet an NPR list of the best 100 YA and children's books included none of his titles. Chris will speak with us about his experiences and challenges as an author and also the challenges to his books. First, we're going to briefly have Kristen Picole, the Assistant Director of the ALA Office for Intellectual Freedom, speak with us. She has had personal experience with a very involved challenge while working as a young adult librarian, and she now helps people navigate challenges and censorship-related issues. Before we hear from Theresa, Kristen will tell us about the Office for Intellectual Freedom and the ways she and fellow staff are involved with intellectual freedom for minors. We'll hold a question and answer session after both Theresa and Chris have shared their presentations. But if you think of questions throughout the program, feel free to send them to us via the message function, and we'll address them at the end. And once again, thank you for joining us, and here's Kristen.
Thank you, Joyce. So I'm going to be really brief because I want to save as much time as possible for our great speakers. The Office for Intellectual Freedom is a team. We are a unit within the American Library Association. We not only work with other divisions within ALA, like the Public Library Association or AASL, the American Association for School Librarians, we work with other organizations and state chapters. We focus on two main missions. First, supporting librarians and educators that are going through book challenges and privacy issues. And second, we focus on education and advocacy through public speaking, writing, professional development, and programs like Banned Books Week and Choose Privacy Week. We encourage anyone to call us if they have questions or need help. You don't have to be an ALA member or a librarian. We define censorship as a change in the access of material based on the content of the work and made by a governing authority or its representatives. Such changes include exclusion, redaction, restriction, removal, or age grade level changes. Many cases of censorship happen in school libraries and youth books. Of the challenges that are reported in 2015, 28% of them happened in schools pertaining to their curriculum and programming, and on top of that, an additional 19% of challenges happened in school libraries. Censorship can be concrete. The book was in the library, and now it's not. But soft censorship is harder to define, and it can come in many different forms. It's an area where we get many questions. Many of these ideas are practices that we advise against, but cannot say is legally prohibited. Soft censorship is not a legal term. Examples include requiring parental permission, restriction based on leveling of the books, restrictive shelving, misshelving the books to hide the materials, or indefinitely keeping materials in an office. One of my favorite examples is when nude illustrations are covered, like The Happy Naked Little Boy in the Night Kitchen by Maurice Sendak. But people will say, as long as the book is there, what's the difference? But how we treat the books and the topics, especially to minors, makes a big difference. When children's books, like And Tango Makes Three, are shelved in a parent's collection or a nonfiction area, there is a chilling effect that discourages a legitimate exercise of a natural and legal right to that book. And now is the perfect opportunity to bring in our expert, Theresa Chmara, to talk about that legal right.
Hello, can everyone hear me? So I'm really glad to be here today. I wanted to start by just addressing the, main question. Do minors have First Amendment rights? And they do. And the Supreme Court has made that clear. Not only do minors generally have First Amendment rights, but they have them in the school environment as well. So in the Tinker case, which is in the first slide, the United States Supreme Court held explicitly that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. That case was an interesting case. The students that were at issue there, who had been actually suspended, had worn black armbands around their arms in protest of the Vietnam War. They were asked to remove them, they wouldn't, and then they faced suspensions. And they challenged it and took the case all the way to the Supreme Court, where the court held that, yes, they're students and they're in school, but that doesn't mean that they don't have the right to express themselves and in a way that doesn't substantially disrupt the school environment. And that was the test that the court Sounds like some folks aren't hearing me.
Yeah, can we have you turn up your volume a little bit? You should have a microphone volume underneath the microphone icon if you need.
Yeah, it's as high as it will go. How's that? Better? All right, I'll just start back and just to make sure everyone can hear then. I was talking about the Tinker case, in which the Supreme Court held that students or minors not only have rights, First Amendment rights, but they also have them in the school environment. Now, it is going to be a different environment than outside of school, and if speech is substantially disruptive of the school environment and the educational process, then that's a different story. So, for example, students couldn't just pick up, posters and decide to leave class and march up and down the halls in protest of something. But in the case of Tinker, where the students wore black armbands in protest of the Vietnam War, the court held there was no evidence whatsoever that there had been any sort of disruption that there would be. And then, in fact, it was almost pure speech, symbolic speech, for them to wear those armbands and to let everyone know what their views were. So that's an example of a case where it's students speaking, but it also applies to receipt of information. And in the Board of Education v. Pico case, the Supreme Court held that the right to receive information is the corollary to the right to speak, and that students, too, are beneficiaries of this principle. So in that case, where 7 books had been censored, taken out of the library, and there was a challenge about it, the court held students have the right to receive that information, and school officials don't have absolute discretion to just say, we can remove any books that we want from the library. So we're talking about the right to speak for minors. They have that right, and also the right to receive information. Before I start talking about some of the cases, to give you some examples of the cases that have been out there, both when minors want to speak in the school environment and also when they want to have access to certain information, I wanted to talk for a few minutes about parents, schools, and libraries, because there are some terms that sometimes are thrown out there that don't really apply. So the first thing, just to really emphasize, and not everyone always understands this, is that the First Amendment prohibits the government from infringing free speech rights. It doesn't apply to private entities. So in all the cases that I'm discussing today, and when we're talking about minors' rights, we're not talking about private schools. We're talking about public schools or public libraries. And the First Amendment applies to the government. So the First Amendment doesn't restrict the rights of parents to select material for their own children. Parents have that right. One legal term that's often thrown out there is in loco parentis, and literally it means in the place of the parent. And that is sometimes raised as, do librarians serve in loco parentis in the public library? Do teachers in schools serve in loco parentis in the school environment? And does that give them more authority then to curtail First Amendment rights of minors? So first, in the public libraries do not in any way serve in loco parentis. If parents wish to guide the selection of material for their children, their own children, they have to accompany their own children to the library. The librarian, you can't just send your child, to the library and expect that the librarian, in fact, the librarian can't say you can, take this material out or look at this material or not. They don't serve in that way. Schools, to a limited extent, do serve in loco parentis. They do take the place of the parent. That's defined by local state law. For example, if you're talking about, suspensions for exercising free speech rights, it's state law and local law that will determine, what the rules are, what are the disciplinary rules, what, can be suspended in school, out of school, 2 days, 3 days. That's the sort of thing that's, again, defined by state or local law. The way that schools serve in loco parentis is to protect the safety of the children in their care and to discipline or curtail disruptive behavior that impacts the educational environment or, again, threatens the safety of other students, other teachers, or staff. But the courts have been clear that that does not mean that school officials can infringe on constitutional rights. So that the first case I talked about, for example, in Tinker, the school couldn't, because they were in loco parentis to a limited extent, say to the 3 students, you can't wear those black armbands. Now, their parents could have said, you're not leaving the house wearing those black armbands, but that doesn't transfer and give the authorities that type of control over the students. And this has come up also in cases of, can lockers be searched? You know, schools have said, well, of course they can. We serve in loco parentis, and you know, a parent could search a child's room. That doesn't violate the Constitution, so we can do it as well. And the courts have said no. Civil rights are still intact as you cross that threshold going into the school, and the school officials can't infringe on those constitutional rights. So that does bring us to, though, pointing out, though, that adults' rights and minors' rights, as far as the First Amendment, are not exactly the same. There are 2 instances in which minors' rights are narrower. So when we're talking about, for example, access to material or removing material from the school or the school library, school officials can only remove materials if the decision is based objectively, not subjectively, but objectively, on a finding that the material is educationally unsuitable. And I'll talk about that test in a bit, but I just wanted to sort of talk about the 2 instances first. The second instance is materials can be deemed obscene for minors or harmful to minors, even if they would not be deemed obscene for adults. There are basically 3 categories of speech that are not protected by the First Amendment, and that is obscenity, harmful to minors material, and child pornography. So the courts have carved out a separate category of harmful to minors, and I think most states, if not all states, do have harmful to minors laws, and or harmful to juveniles, they're sometimes called, and that is a category of speech where minors' rights are narrower. So I want to go back then to educational unsuitability. If a book, say, was removed from a library and there was a challenge to the book, the only way that it can be removed is if it was educationally unsuitable. So your school board officials, your principal, whoever made the decision, would have to make that showing in court, and it's going to be a fact-based inquiry. And it will generally require expert testimony. A judge is not going to just accept that the school board official or the school principal says, well, I'm an educator, or I've been on the school board 20 years, and I know this is not suitable for the kids. They're going to want to hear from experts, objective experts that are not part of the school, to talk about why that book is educationally suitable and for the library or to have in the school. And again, subjective disagreement with or disapproval of the content is unconstitutional. If that's the reason for the censorship, that's unconstitutional. And I'll talk about a few of the cases to give you a sense of how courts approach that. But basically the motivation, what is the motivation? Which, you might say, well, how would you know? Everyone's just going to say educationally unsuitable. How do we know what their real motivation is? It turns out, as I'll talk about the cases in a bit, that courts have been able to tell when the officials making the decisions had an unconstitutional motivation rather than an objective determination as the basis for the finding that the book needed to be removed. Also wanted to talk a little bit about the harmful to minors. So I said that was a second instance where states, can have a separate category of material that's harmful to minors. So it would not be obscene as to adults, but it would be deemed essentially obscene as to minors. But there are limitations to what a state can do and how it can define that. First of all, courts have held that states cannot simply ban an entire category of speech, such as nudity. So they can't just say, well, if there's nudity, then it's automatically harmful to minors. It still has to meet a very stringent definition, and it can't be an entire category. The other important limitation that the courts have held or found is that the determination of whether something is harmful to minors has to be made by reference to the entire population of minors, including the oldest of minors. And basically that means that when a court is making that determination, it can't be that it would be deemed obscene for a 5-year-old. It would have to be that it would be obscene with respect to the oldest of minors, including 17-year-olds. So that is basically a limitation on what states can do and the limitations that apply when the courts review these cases. The test itself is the same as the test for obscenity, but it's with reference to minors rather than adults. So it's whether the average person applying contemporary community standards would find the work as a whole appeals to the prurient interests of minors. And it bears noting here that it's contemporary community standards that apply, so that if something were found harmful to minors in one state, it might not necessarily be found harmful to minors in another state. It's the community standard that the jury or the judge, if the judge is the fact finder, is looking to. And the second is whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. So each state law could be defining sexual conduct in a different way, and they do have different terminology, different ways that they define that. The final important part of the test is whether the work taken as a whole, not one page, not one chapter, not one paragraph, but the work taken as a whole lacks serious literary, artistic, political, or scientific value for minors. And one thing that I do want to stress is that as with finding about obscenity generally, only a judge or a jury can make this definitive finding. So it's not enough that somebody says, well, look, this meets the definition of the statute and would, meet this test. It actually has to be adjudicated in a court to be found to be, whether it's obscene or harmful to minors. And again, just a quick reminder that it's contemporary community standards. So even if a court in one state held that it was harmful to minors, that doesn't mean that another community, according to its own community standards, would find that it is. So that's our basic definition. And I wanted to go back then to talk about speech, minors actually speaking, their speech, and go back to a discussion of some of the cases in the school library context. And one thing that the courts have definitely found is that students' First Amendment rights in the school library context are broader than those in a classroom, a school-sponsored assembly, or other curriculum-based activity. So there will definitely be a difference in the authority and the discretion that a school board or school officials have over curriculum or school activities, sponsored activities, versus the school library extracurricular. Hazelwood School District v. Chmara was a case that involved a school journalism class. And it was a class, it was graded, and as part of that class, the students put together a newspaper that would be distributed. In that particular case, they had 2 articles, one about teen pregnancy, where they profiled a number of teens in the school and talked to them about their being having pregnancies as teenagers and being in school. They had planned to make those profiles anonymous, but nevertheless, the school principal said the article had to be pulled because he felt that the anonymity wouldn't really work, that it would be very easy to see who the students were. The other was about divorce and had statements by one of the students in which she very specifically talked about her father and how uninvolved he was in their family life. And the principal felt that that also was something that needed to be pulled. Now, I had mentioned earlier that in Tinker, the court had used a standard or a test of substantial disruption. But in this case, what the court said is that since this was part of the curriculum, because it was a school journalism class, that it was a school-sponsored activity. It's not the same thing as the students simply wearing armbands on their own arms to make a statement, but this was actually a school-sponsored activity, and that the school officials in that case could make the decision to restrict the speech as long as it was reasonably related to legitimate pedagogical reasons. And the court found in this case that that existed, again, because it was a class. In another case, Bethel School District, it was a school assembly case. It was a middle school student. There were student elections going on, and the school facilitated an assembly where the candidates could speak and students could speak on behalf of other candidates. One of the students made a sexually explicit speech trying to gain endorsement for votes for one of his friends who was running. And because the speech was sexually explicit, he was disciplined the next day, suspended for some amount of time. Again, this case went all the way to the Supreme Court. And here again, even though there wasn't a real disruption during the assembly, where they were worried about the safety of students, the court said that the difference here was that the school did have a duty to teach students about public discourse, and that they could send the message that in the school-sponsored assembly, they did not condone sexually explicit speech. One interesting thing about this case was that even the more liberal justices on the court agreed that the suspension was permissible and not unconstitutional, but they all made a point of focusing or emphasizing that if the student had made that same speech outside of school, there would have been no repercussions. It was simply because it was in a school-sponsored assembly that it made a difference. Another more recent case is the Morse v. Frederick case. This occurred in Alaska, where the students had been let out for what was deemed sort of a class trip day to watch the Olympic torch relay come through. And one of the students, or a number of the students, unfurled a banner which said, "Bong hits for Jesus." The principal saw it because the principal and teachers were out there supervising the students and told the student to put it away. He wouldn't. He was, again, disciplined, suspended. When it got to the Supreme Court, the court upheld the principal's actions and said they were not unconstitutional, but very, very focused on the fact that the school had the right to, because the school did not want to promote illegal drug use, and this was seen as promoting illegal drug use, that the school did have the right to intervene and to restrict that speech. Several of the justices, including Justice Alito, said that there would have been a different result if the sign had advocated legalizing marijuana instead of being interpreted as promoting illegal drug use. So that was a difference. So as you can see, these cases, you can have a test, but it gets into the nitty-gritty of each case, and these are just highlights of some of the more important Supreme Court cases on the subject, but lower courts grapple with these issues all the time, and they are, again, very fact-based. What was the circumstance? What were the rules? What was happening in that context? I wanted to also talk about a number of school library removal cases. As I mentioned previously in talking about the Board of Education v. PICO case, the court in that case held that you couldn't remove books from a school library, again, unless you could show that they were educationally unsuitable, and that the lower courts since then have looked to what was the motivation. And as I mentioned, that can be hard to maybe discern, you would think, because what school board member or school official, knowing the test, isn't going to say, well, we removed it because it was educationally unsuitable. So you're going to have expert testimony. But the courts will also look at how the process was handled, for example. So in the Campbell case, which involved the unconstitutional removal of a book about voodoo, and the court did find it was unconstitutional, the court looked at a couple of things. When once a case is filed, there usually will be sworn depositions where each of the school board members that voted to remove it will be asked, well, what, did you read the book? Why did you remove it? And the court found in reviewing that evidence that most of the people, the school board members who voted to remove it, had not even read the book. Some hadn't even seen the book. Some only saw excerpts that were shown to them, and that, the court said, it was a pretty good indicator about what their motivation was, which is disagreement with the content of the book, subjective disagreement, rather than any objective finding of educational unsuitability. The other thing that was important to the court is that this school had its procedures in place, like many do, which said if a challenge comes in, it goes maybe to this committee first, and then they vote on it. Maybe it can be appealed to another committee, and they had a multi-layered process here. And interestingly, every single step of the process, every committee, the appellate committee, everyone said we should keep the book. It's educationally suitable. Nonetheless, at the end of the day, that was all disregarded. All those procedures were disregarded, and the book was removed. A similar thing happened in the case, the Unified School District case, which was the unconstitutional removal of a book titled Annie on My Mind, which touched upon issues related to homosexuality. And again, the ultimate decision maker did not follow the procedures, ignored all the recommendations of all the steps or the committees that had looked at it, who said that you should keep the book. And in that case, to be honest, the depositions, they weren't subtle at all. The school board members that voted to remove the book in that case very explicitly said they disagreed with the content in the book and didn't think that students should have access to books about homosexuality. So it wasn't a very hard decision for the judge to say that the motivation there was unconstitutional. I wanted to also briefly touch upon the Counts v. Cedarville School District case because it had some there were some interesting parts to that. This was the unconstitutional removal of the Harry Potter series of books, and it sort of goes back to something that Kristen mentioned earlier. In this case, the removal wasn't to remove it completely from the school library. It was just to remove it from the open shelves, and it was placed on a restricted shelf where a student could only have access to any of the books in the series if they had parental permission. One of the first issues that came up was a question of legal standing. So if a book gets removed, such as the Harry Potter series, I might think that's a terrible thing, but I can't go in there and file a lawsuit to challenge it because I don't have an actual injury. So it has to be a student in the school that challenges the removal, a student who can't get access to it. And in this case, the student did file a challenge with her parents. And one of the things that the school argued is, well, she doesn't have legal standing. She already has the books at home, and her parents will obviously give her permission. If they went so far as to file a lawsuit, they would certainly give her permission to get it. And the court said, no, she still has standing to sue. And the question is, it's still restricted for her. There is a burden placed on the exercise of her First Amendment rights. And so she does have the legal standing to challenge that. And in this case, the school board, the school officials were arguing that the books were educationally unsuitable because they promoted disobedience to authority and witchcraft. And the court found that neither of the excuses could be supported as educationally unsuitable. And the court found that even though the book had not been removed from the library altogether, it was still unconstitutional, a violation of First Amendment rights. The court's belief was that if it's educationally suitable, and they hadn't shown that it wasn't, then a student should be able to go to the library at any time and take the book off the shelf and read it. They shouldn't have to get their parents to sign a permission slip. They shouldn't have to go find a librarian to make sure they can get it. They shouldn't have to have the stigma, the court said, of being seen as asking for something that had been put on a restricted shelf. So that was it was a lower court decision, didn't go to the Supreme Court, but a really great case for showing how any burden on rights, even if it seems minimal, is still unconstitutional if the test can't be met. I only have a few more minutes here, so I wanted to touch upon briefly also internet access and filtering. The Children's Internet Protection Act, CIPA, requires filtering by schools or libraries that receive certain funding, and it requires filtering of visual images that are obscene, harmful to minors, or child pornography. And as you recall, those are the three categories of speech that I said were not protected by the First Amendment. And we all know that filters overblock and they underblock. There isn't a filter out there that can do precisely this, that can block out visual images, only visual images that are obscene, harmful to minors, or child pornography. And it won't get all of those images, and it will certainly block more. There was a challenge to CIPA, the United States of American Library Association case, but that challenge was with respect to adults and only with respect to public libraries. So it didn't have anything to do with minors or school libraries. And the court did uphold CIPA in that case, but because the Solicitor General at oral argument had made it clear to the Supreme Court justices that public libraries could disable the filters for adults, and adults would not have to go through hoops to prove why or show why they wanted to disable it. If an adult asked for it to be disabled, public libraries could disable it, and therefore it wasn't unconstitutional. There was a lower court case, the P-Flag case in Missouri, Camdenton, Missouri, which had to do with a challenge to school internet filtering. In that case, the students who challenged it said that the internet filtering that was in place at the school would block access to websites that promoted a positive view of LGBT issues. It would allow access to those, but it would block access to negative, any negative, it would allow access to any negative websites that dealt with LGBT issues, but not allow access. If it was making negative comments, you could access it. If it was making positive comments, you could not access it, sorry. And the court there found that that was an unconstitutional viewpoint discrimination violation, that students had the right to access all of that content. The school did have an unblocking process in place, but the court found that it was cumbersome, so you would not be able to get to material. Students couldn't get to the material they wanted to access immediately when they needed it or wanted it. And also, again, back to the whole idea of stigmatizing, that this is something that's blocked and that students would be reluctant to go ask for something that someone had said should be blocked. I just want to touch upon one more thing really briefly, which is minors in the public library. I've been talking about all these cases that take place in the school library because that's where most of the challenges and cases are. But we did have one case in Wichita Falls, Texas, where books had been removed from the children's room of the public library and placed in the adult section of the library. And this happened by ordinance. If 300 people in the city of Wichita Falls signed a petition saying that a book should be removed from the children's room, then the public library director was required to remove it. And this happened with two books, Daddy's Roommate and Heather Has Two Mommies, and that was challenged, and the court found that it was unconstitutional. And again, because it's the public library, this test is even more stringent. Unless the material can be shown to be obscene, harmful to minors, or child pornography, which obviously these books could not, you would have to show that the removal was necessary to achieve a compelling government interest and was narrowly tailored to achieve that interest, which the court said they could not make that showing in the city of Wichita Falls. And again, this court also said, yeah, they're still in the library, but it's still an impermissible restriction on First Amendment rights of minors because they can't just come across the books in the children's room. They would have to go seek it out. Adults, their parents couldn't find the books there. Again, there was too much of a burden on the exercise of their rights. So quickly to conclude, yes, minors do have First Amendment rights, and those rights do exist in the school environment, and government officials, school officials do need to be mindful of that. Decisions to censor material or speech or to discipline students for their speech. Thank you.
Thank you, Theresa. This was so informative. I want to turn it over to Chris Crutcher. Have him turn on his webcam.
Can you hear me?
I can hear you, yes. You need to share your webcam.
Share my webcam. Oh, there we go. I'm sharing it with myself. It seems like I should share it with everybody.
You should share it with everyone.
Does that work?
Yes, perfect.
Well, for me, it's always great to hear some of the specifics about the legalities and details of what you can and can't, what can and can't be censored, or what can or cannot be acted upon. But a lot of what I want to talk about today is just um, the practical kind of personal part of book censorship and my experiences with it. All those books that Kristen talked about have all been banned someplace. So I have a lot of history with this. And you know, it's funny for me. The first time a book of mine got banned, it was a book called Running Loose, and Running Loose was my first book. I wrote it back in 1982. I think it was either 83 or 84. It had worked its way to one of the top 10 books in the country that had been banned during that year. And there was an article about it in USA Today, and there was a little panel, one of those little blue panels off to the side, that had listed the books. And there were, out of those top 10 books, there were 9 books that were, I mean, I was on the list with Kurt Vonnegut and Harper Lee and, you know, some of my all-time very favorites. So there were nine books of very, very famous authors and one book by a guy nobody knew. And so I was really proud of that. And I probably spent an entire royalty check on USA Today that day, and then just cut out the little blue panel and laminated it and sent it to my friends as bookmarks. So there's a part of me that's kind of, I mean, I write for adolescents partly because I never got over it. But to me, there's a playful part of it, and some of the playful part of it for me is that this book banning thing, this argument about book banning, seems silly to me. I mean, number one, if somebody actually is successful in banning a book in a school district someplace in the country, one of my books, I send 5 copies of that book to the nearest local public library, and I call the TV stations and the newspapers to let them know that they're there. Because what I want people to know is this is the United States of America, and you can't ban a book. Anybody that can get access to an internet and a credit card number can get any book they want. And for the most part, anybody that can get into their public library. There are times when books are formally censored in public libraries, but it's not often. So most of my struggles with censorship have been either in the curriculum or in voluntary reading lists and things like that in schools. Now, you know, I look at the groups of folks who want to ban books, and I usually find them on the conservative side. There's either a fundamental religious piece or there's a real staunch conservative view about what kids should be able to read and who should be able to decide. And it's a funny thing to me because I was born in 1946. I'm the front end of the baby boomers, and my father was as conservative as you get. He was a patriot. By the time he was the same age that I was when I graduated from college, he had flown 35 missions over Germany in a B-17, and he was the pilot. And so he was a staunch patriot, and he came back to this small town that I grew up in, Cascade, Idaho. And he was on the school board. He was always involved in community projects. My dad would have run a nail through his eye before he would have let a book get banned on his watch. He thought he fought a war for that. So there was a whole my wiring, even though some of, and anything, if you've ever read anything of mine, you know I'm not very conservative anywhere. But even with my conservative wiring in terms of my upbringing, there was this understanding of the Constitution that basically said we should take care of those issues ourselves. The very best censor in the world is you. You can pick up a book, you start to read it. If you don't want to read it, close it. If you do want to read it, keep reading it. If you understand it, then you're probably capable of reading it, and it's probably okay. You might want to share it with somebody. If I'm a parent, I absolutely want to know what my kid's reading because I want to have conversations about that. But the whole personal piece of it gets gets more interesting than that for me, because for one thing, any principal, anybody can ban a book out of, in a school any way they want to if nobody challenges that. There's case after case after case where a principal walks into a high school and says, I want all books of, all books with homosexual characters that aren't either freeway snipers or serial killers taken out of the library. And if it doesn't get challenged, and that administrator is deemed as being the authority, that's the end of it. So that's the struggle that I tend to run into. And as I kept writing books, and each of those books kept getting banned someplace, or in more cases challenged in one place or another, I started to wonder if I had crossed some line between, looking out in the real world and finding stories to tell, and then bringing those stories into fiction. And I thought maybe there was a line that I just didn't recognize, or that maybe there was even a good reason for some of this, even though I couldn't find it. Well, I was in my office, in my years as a therapist, I was in my office one day, and I was working with this 16-year-old girl, and she was a kid. She had a really horrific sexual abuse history, and she had been molested within the family from before speech, and it had only ended when she made the disclosure and was referred to me. But we'd been working together for quite a while, and I gained her trust, and so we were talking about some of the really, she was a kid who was a perfect athlete and a perfect student and all that. She was like, look over here in this part of my life where I'm great, and don't look over here. And we were at what my life is really like. So we were having a talk about that one day, and she knew I wrote stories. And I looked at her and I thought, God, this kid is in a school right here in Spokane. And there's no way in the world anybody in the school knows this story. It's the only protection this kid has is she has control of the secret. She gets to decide whether she talks about whether what she considers is this horribly shameful thing in her life to be talked about. And so we talked about it a little while. And like I said, she knew I wrote. And she said, I haven't read anything about it, anything like that. You ought to write this story. And my history had always been to write stories that I had some experience with. And I'd had some experience with kids who had suffered from those kinds of things. In fact, at the time I had 3 or 4 girls and a couple of guys. But they weren't in my wiring at all. And so we talked about it a little bit, and I said, well, I could write this, but I'm going to need you to help me edit it, because there's no way in the world I can write a story like this and have it be wrong. Well, she had another friend who was also a client of mine, and the two of them were voracious readers, and they were going to edit this book that I was going to write. It ended up being Chinese Handcuffs. So I wrote Chinese Handcuffs. It was my 4th book, and I got it out there. It got out into the world, and boy, my first 3 books had been pretty roundly approved, even though they got challenged and things like that. Chinese Handcuffs was 50-50. People who loved it loved it. The people who hated it hated me. And there was really a lot of discussion about the story. And again, I thought, God, I wonder if I crossed some line that I didn't know was there. I'm down in Houston, Texas, and I'm talking to one of those huge, 4,500 student schools. And in Texas, they never divide the school and turn it into 2 because it messes up the football team. But I'm talking to a large auditorium full of kids, and the speech is over, and the kids are coming down and talking, and I'm signing some books, and we're having discussions about what I talked about, and stories they wanted me to tell, and stories they wanted to tell. Girl is kind of sitting back here, and she's just waiting. And I can feel her back there. I can tell that this kid is going to talk to me. She has something to say, and she needs to say it to me in private. So she waits like 20 minutes, and the kids all walk away. And then she steps up, and she says, I don't have any questions or anything, but I just wanted you to know that when I read Chinese Handcuffs, I thought you knew me. And instantly, all my questions about whether or not I should have written Chinese Handcuffs and whether that was an area into which we should go were answered. She said, I read the book. She was pretty funny. She said, I figured if some old guy in Washington knew about this, there had to be other people too. In other words, I no longer felt alone. She said, this is the first time I've told anybody. Now she's 17 years old. She's getting ready to graduate. She's really smart. She doesn't tell me her name because she knows I'm a mandatory reporter. We talked for quite a while about the story and kind of her, what do I do? And she's asking me what do I do? And she said, you're a therapist and I could be a client, but you live in Washington and I live in Texas. And totally out of desperation, I said, well, who gave you the book? And she said, the school librarian. And I said, well, did she give it to everybody or did she just give it to you? And she kind of thought for a second. She said, I think she just gave it to me. And I said, I'd go with the school librarian. Well, she was graduating in like 2 or 3 months. I kind of, I remember the story, but it kind of fades in the back. But I get letters. And it's back before email. I get 2 letters within a week. One from the school librarian, one from the girl. They've talked about it. They're going for help. Now, I don't know the end of that story. I don't know how it turned out. I know she had to find a good therapist. I know she had to be able to have access to that therapist. But I do know a couple of things. I know the chances of her being able to process what had happened to her were far greater. I know that she found somebody that she felt safe with, that she could talk to. And now that she was over 18 years old, there was no question of having to bring in child protection services and things like that, unless other than to just go back and get the perpetrators. And I don't know whether that happened or not. But what I walked away with was I was kind of the conduit between these kids that were sitting in my office telling me what their lives were like and telling me how secretive they had to keep their lives and how they had to always make sure that somebody saw this part of them and not this part of them. And this girl in Texas, and there's a connection, and they made the connection, and things get talked about. And things getting talked about, I think, is the power of story. Now, I look back at the kinds of things that I've been censored for or the things that my books have been banned for. Put a homosexual character, like I said, in a homosexual character into a book who's not a serial killer or a freeway sniper or something like that, and a whole bunch of states are going to go after you. A whole bunch of districts or school districts, states that are real conservative are going to go after you because somehow they get this idea that you're promoting that, even though what I'm doing is saying, well, 10% of the population, okay? And if you talk about sexual stuff, if you talk about a lot of philosophical things, you get into religion, any of those kinds of things, you get into a character who defies authority, and then you're going to find that fight. If you in my books, and this is something that's come up time and time again, I have in many cases of my stories racist characters, people who are just absolutely, openly, blatantly racist, people I grew up with. And they use racial epithets. They don't call it the N-word. And they use racial epithets for whatever group of people that they don't like. And I don't think you can portray hate without using the language of hate. And if somebody, and this happens so much of the time, people will go through and they want the issues in a book banned, or they want their pieces of those stories that make them uncomfortable. And so one of the things they do is go through and they just pick out the bad words. And then they when they go to the school board or when they go to wherever they're going to go, that becomes the war. Now, the one thing that I found out, and I'll open it up for questions after this, is we have this fight all the time. We have this argument about, what can we talk about in stories and who has the right to say what. And I just totally coincidentally got into a book banning situation in someplace in Iowa. And there were 2 books that they were working on. One of them was my book Whale Talk, and the other book was Fallen Angels by Walter Dean Myers. And it was one of those. It was a small community, and there'd been a lot of uproar on both sides. And so the night that I happened to be there, and I'd been doing a school visit in a town very close, so I came to the school board meeting, and the school board meeting kind of put out this is the problem, and then the people who were against having the books in the school got up and said what they had to say, and the people who were for the books staying in the school got up and said what they had to say, and nobody's mind got changed. But then a group of kids came up to the microphone, and they were all high school kids. They were readers of these stories, and so several said something. One kid stands up and he says, I'm 18 years old, and I could be a Division I athlete. I have offers for scholarships. I could go to almost any Division I school that I want to play football. Um, and I could, academically, he said, I'm a good writer. I've never had a grade under an A in English class. And he kind of put himself out there as a real, one of those students we all want. And he said, the next year I'm not going to be playing football at a Division I school. I'm going to be, probably I'll be in Iraq. This was back before, when the Iraq War was really going. He said, because that's the thing that I want to do. He said, do you guys mean to tell me, and he was making reference to fallen angels, he said, do you guys mean to tell me that if I go over there and serve my country and come back here and decide to write about it in the language of a soldier, you're going to ban me in my own school? And it was done. I mean, if that guy had come first, we'd all been out having a beer. And for the first time, I think these school board members got to see who it was they were trying to take the books away from. And I think that's a hugely important thing, because on the one hand, this is a philosophical discussion. On the other hand, it's a question of whether we can bring the real truth of human problems into the classroom, give kids and teachers a chance to talk about those things without having to talk about their own personal lives. And all of a sudden, everybody knows a little bit more about what it is to be human. And that, in my world, that's the fight. When I sit down to write a story, I don't sit down to write a story to get banned, but I almost always know I'm going to be, and I don't care. So that's kind of the personal side of it. And I know we're running a little bit short on time. I wanted to leave some time for questions, so I will run that back over. And never been asked a question I wasn't willing to answer. So.
Thank you, Chris. All right, I'm going to switch us back here. All right, who's got questions? I've got a couple from before. Theresa, Jamie had brought up a question earlier that I wanted to ask you. Vulgarity, would that be a subset of speech that cannot be banned?
Well, again, I think, can you hear me?
Yes.
Okay, so I think that in that case, it's going to be one of those things where it's going to be in the context of the particular, situation. So that one case that I talked about, Bethel, the court found that the school officials could discipline the middle schooler who used sexually explicit speech in a school-sponsored assembly. So you can't just say yes or no. It would have to depend on the context of the case. Where did it happen? Those sorts of things would have to be looked at. But you couldn't say that vulgarity, like nudity, for example, you can ban that as harmful to minors as a completely, without looking at the context.
All right. Maria had asked earlier, would telling a minor they need to ask for permission from a parent to read something constitute soft censorship?
Well,
Do you want me to answer this one? Go ahead, Theresa.
Not a legal term, so I'll let you take that one.
One of the things that we often recommend in the office regarding parental permission is to, if you're having questions about a specific book, or is to have the whole list looked at by a parent. Have a parent sign off on the entire curriculum, the entire reading list. Give them the chance to opt out at any of the books that they have available, because you don't know what's going to offend one parent, one family, or another. And so don't take into your own judgment what you think parents are going to be offended about or controversial about. So, it would be considered soft censorship. Right. There is a question about the legality of public libraries restricting minors' access to checking out portions of the collection, for example, DVDs, based on a card type, adult versus child.
Do you want me to take that, Kristen?
Yes, please.
Okay, so certainly if there's a restriction on minors' rights, that is censorship. We haven't had a case where the courts, the Supreme Court has addressed whether that meets the standard of educational unsuitability or not. So I can't say definitively what, the Supreme Court hasn't addressed that, but, certainly minors have the right to access material. If we're talking about a public library, you'd have to make a showing that there was a compelling interest and that the state or the local authority had to restrict that material, and that was narrowly tailored. And, that's a very, very tough standard.
We have, within the ALA Library Bill of Rights, the interpretations addresses that as well for the access to minors and different resources that aren't necessarily book-based, but that could be electronic or digital, things like that. So I included a link there for the interpretations that kind of explain some of that.
And I just noticed Deborah was going back to the Counts decision, which I did talk about, and that was a case where the court did say that if you can't make the showing that it's educationally unsuitable, then you have to have access to it, and putting it on a restricted shelf was found to be unconstitutional. That's a lower court decision, but we haven't had the Supreme Court address it. But certainly the lower court has said either you meet the test or you don't, and restricting it is an impermissible burden on First Amendment rights.
Kimmy says, Chris, I second Jamie. Thank you for sharing those stories. I loved hearing about the girl you guided to her librarian so much. I also love that you had your client edit the book. Should ask you to write. Thank you so much.
I really appreciate that. One of the things that's true, one of the things that I always knew as a therapist was, not very many kids get to go see therapists, but everybody goes to school. And even though, you may or may not be trained as when you're a librarian or when you're doing all your teaching kinds of things to deal with the kinds of things that are going to come up in school, they're always going to come up in school. And I think the fact that there are people standing up for kids' rights to read stories and to have conversations with each other and in a formal way, and with adults, with responsible adults who have read a whole bunch of stories and know which ones to put in the hands of which kids. That the fact that the kids start to understand that they do have the right to do that gives them a place to do what the very, very few kids who actually end up in a therapeutic situation get. And because to get into a therapeutic situation, very often a lot of really, really bad things have to happen to you. And there are a lot of kids who are just trying to get by, who just don't understand that, what's going on in their lives and what's going on with we talk about some of the really awful abuse situations, but there are a whole bunch of, things that happen with kids that they don't understand. And there are good writers out there telling amazing stories that open up conversation. And that's what free speech is. It's conversation. It's that whole idea of being able to think about something, consider it, talk about it, get somebody's opinion that you trust. It makes life a lot easier.
Yeah, there's such great learning tools for families and friends too. And it's not always the reader who's seeing herself or himself in the character of the book, but it could be recognizing your best friend in that character and being able to reach out for help for that.
And the whole thing is, what stories do is get into people's imaginations. And I mean, when you get into the imagination, now you're talking about real learning. Now, I mean, if education doesn't make your life better, what good is it? And for this to happen, so much has to happen in the imagination. I always think that I have a contract with the reader. I'll bring my best imagination to the telling of this story. You bring your best imagination to the reading of this story, and there's a real good chance that the book will be better than it ever had a right to be because of the history that you bring. And that's where the real true conversation, that's where education happens.
Which I think is one of the reasons people fall in love with book characters so often.
Absolutely.
Well, we are at, oh wait, here we go. Jamie has a question. As a therapist, you may have some knowledge of this. What is the estimated incidence of abuse? Higher than the 10% you alluded to as an estimate of gay characters?
Yes, I think when I look at that, and I'll say this real quick. I worked with a therapist when I started working at the mental health center way back in the 80s, and her expertise, and she was one of the best like ever. And her expertise was 5-year-old and under who had been somehow sexually mistreated. And she worked 12 hours a day, 4 days a week, and 10 hours a day on Friday because the center closed. And she had a 6-month waiting list in a town of 250,000 people. And when you go back and say that well under 50% of cases ever get reported, you're talking about if that's an epidemic of I mean, if that was a deadly disease, population control would be no question. I mean, and of course, I mean, when you say abuse, a lot of what you get into at that point is what constitutes abuse and what just constitutes bad treatment and all of that. But any way you cut it, those numbers are horrifying. And then when then I would get those kids out. My expertise was like adults and adolescents and things like that. And story after story after story would happen. And then when I wrote, particularly after I wrote Chinese Handcuffs, but even after I wrote some of the other books that I wrote, I started getting letters from kids in my hometown. One of them was my very best friend in like 4th grade. And he wrote me and said, every time you sent me home, you sent me into hell because I was being abused. I was being sexually abused every time I went home. And I went back and I thought, he's my best friend, but I get tired of him after a while, and send him home. And I was sending him in, and he would do anything when I look back on it to stay in my house and not have to leave. And I'll bet out of a town, and this is a town of 923 people. I've had conversations, and some of these people turned into teachers. I've had conversations with probably 7 or 8 people that I knew kind of within my sphere of influence in high school who had been, had those things happen. And those are the people who are willing to say it. So I think it's way over 10%.
I know that we're after 2 o'clock, and I could sit and listen to Theresa and Chris talk all afternoon. I do have to ask, Chris, I hear you have a new book in works.
I actually have 2 new books in works, and they're both finished. This has never happened to me before. I haven't heard back from my editor because I think she fainted. I wrote the one book, and then I decided I wanted the next book to come out first. So there's been a kind of a hiatus between publications. One of them is a book about it's a little more frivolous book about this kid she's a foster kid, and she's been taken away from her family. And the only way, I mean, they're really just an up the holler, crazy family, drug abuse, all kinds of stuff. And there's no way she's ever going to get back with them. So she's in a safe place. She's in foster care, but she has that empty, aching place for her family. And of course, by now, the social workers and things don't want to have anything to do with hooking her back up with her family. So she's kind of devious in getting visits. And she's an athlete. And so she plays every sport she can think of so that her biological parents can come to the games if they will. And she gets these clandestine meetings with her up in the bleachers and things. And she plays in several tournaments. And these tournaments, they're double elimination. So if you lose one game, then you can work your way back up through the losers bracket and play twice as many games, and then you get to see your parents twice as much. So that's the first book. It's called Losers Bracket. The second one came out of kind of a little more horrific experience. Back before Columbine, there was a really horrific school shooting outside of Spokane, about 100 miles. And I'd written a short story that was kind of a fictional depiction of it. And I started getting letters from the kids who had been in the room when the shooting happened. And one of the things that I noticed about them was that several were kids that was in the 8th grade class. And several of these kids were like 8th graders. They already knew where they were going to go to college. They knew what they wanted to do with their lives, da-da-da-da-da. And then this shooting happened. And, I mean, they barely got their GEDs. They were drug-using kids. They had been all kinds of risky behavior, sexual behavior, all of these kind of PTSD things that happened. And when the shooting in Newtown happened, in Newtown, Connecticut, I mean, I at one point I thought, we are finally to a place where we'll do anything to stop this. I mean, this is horrifying upon horrifying. And it's rich white kids, and nothing happened. And so the second book is a book called Some Guy, and it's a story about a guy who shows up in a town 12 years after a horrific shooting. and these kids are juniors and seniors now. They're getting ready to go out into the world, and they've lived with, you know, an inordinate number of suicides, and an inordinate percentage of drug abuse kids and things like that. And they're trying, I mean, these kids, when their lives would have been like, they should have been just like regular lives, they're just trying to survive to get out in the real world. So those are the two that are finished right now on the editor's desk.
When's the release date on them?
I don't know yet. I've overwhelmed them with material. They're reading like crazy. I think Loser's Bracket will come out first, and I would imagine it'll be out within this next year.
Okay. Oh, fantastic. I can't wait to read them. I really want to thank the Freedom to Read Foundation for helping us put together this webinar, and a huge thanks to Chris and to Theresa for sharing both their passion and their intelligence with us today. And I just want to thank everyone for attending. You guys have been great. Feel free to share your thoughts on our Google form. Any last questions for Chris or Theresa? And email me if you need a certificate. So thank you, everyone, for attending today. This has been fantastic.
Thank you for hosting, Kristen. This was fabulous. And Chris and Theresa, thank you both so much for sharing all of your knowledge with us.
Oh, same from me. The fact that if we didn't have you, we wouldn't be out there in the way that we get out there. And understand that those of us that write books that get challenged know that.
Well, we will keep working on providing access.
Really appreciate it.